Attorney Patel.
Good morning, Your Honor. Sejal Patel on behalf of Duncan Purdy. May it please the Court. We're here today to consider two issues on appeal on Mr. Purdy's convictions of maintaining house of prostitution and deriving support from house of prostitution. The first is the issue of the authenticity of electronic mail exhibits that were entered against Mr. Purdy. And the second is a question of limiting instructions with respect to non-hearsay evidence that came in against Mr. Purdy. I'll start first with the email evidence. The issue before the Court is when email evidence by any proponent comes in, what should be the standard by which that evidence is authenticated? Is it enough to say that if someone owns a computer and they have an email address that has their name in it, that necessarily means that any email that comes from that computer or from that account is necessarily a statement that they wrote? We would argue, and many courts around the country have agreed, and this court has reviewed just earlier this year, a case that's somewhat similar on the facts, that is too low a bar for authenticity to allow these statements to come in against a defendant.
Do you, the Williams case is what I think you're referring to, and that analogizes the MySpace to photographs. And I guess my question is, because what I gather from the cases that you cite, that most courts think of email or electronic evidence like this as more, the appropriate analogy is to documents, because you can print it out. Is that what do you think that makes a difference?
To some extent, I would actually say that electronic evidence of any variety is completely different. There are parts of the admission.
You mean it's sui generis? It's not like documents or like photographs?
That's correct, Your Honor. And the reason for that is that electronic evidence leaves with it a trail of information that's beyond what is just on the face of the document itself. That's in the metadata. So when you look at a piece of electronic mail, or in the case of Williams in a MySpace account, a computer forensics expert, or even we, probably in about 10 years, will be able to go poke into that hard drive and figure out who was the author, when was it created, when was it changed, how was it sent.
Isn't that the purpose of a password? If you have a password account, you theoretically are the only person with access to that account. You should not be giving your password out to people. If you do give your password out to people, they will be authorized essentially to write documents in your name.
That was definitely the intent when passwords were probably first created. But unfortunately now, first of all, many people routinely do share their passwords. For example, any law firm partner will likely give his or her password to their assistant at some point in time. That's fairly common practice. Passwords are also very easy to hack into. There's lots of literature about this, but if someone goes to a Starbucks Wi-Fi and they put themselves on the public server, they could be on any one of a number of unsecured websites that still require password access, like Facebook, Twitter, other accounts like that. And another person who's computer savvy can very easily penetrate that account and be that person.
What about, that Starbucks, though, isn't a computer that you have that's your own. What about a presumption that email on a computer that is the email of the computer's owner? Having a presumption that email is of the computer's owner. If the computer person owns the computer, that wouldn't apply in Starbucks. But then let evidence be admitted to contradict that. What would you say about that?
Yes, Your Honor. So you mean the physical hardware, so the laptop or the computer that actually belonged to a given individual.
In this case, that's what it was in this case.
Yes. So several courts, not in Massachusetts but around the country, have considered that question. And in all of those courts have found that by itself, without actually looking at the other content of what that message says, is not enough. Now, in this case, if we were to say, okay, let's say that the hardware alone would be enough. It belonged to Mr. Purdy. He admitted it belonged to him. He produced the passwords to the agent when the agent came in to take the forensic analysis. He also says everyone in that shop had access to the computer. And that was a fact that was unrefuted.
And his passwords.
And his passwords, that's correct. And the Commonwealth, the detectives who went in to do the undercover investigation did talk to people that were in the shop. Many of those witnesses weren't produced at trial, but during the course of those investigations, certainly they could have asked.
So the question is whether there's enough to get it into evidence. Obviously, these are very important subjects for cross-examination, but if it's your own computer and your own password, why isn't that enough to at least authenticated for purposes of getting it into evidence?
Two reasons. The first is and this is not even a sort of criminal Commonwealth versus defense issue. This is a proponent of evidence on any side in a criminal or civil matter type of issue. That would it be enough just to say that's your computer and that's your email? And we would say there's two reasons why it's not. First of all, it's incredibly easy to prove, if you wanted to prove and if it exists, that a particular email correspondence actually did come from somebody. So if you look at some of the other cases that are cited in my brief.
Looking at the contents.
That's correct.
And
so it could
connecting
be
the contents to the facts of the case.
Exactly. So it could be things like a person has a particular nickname and the nickname is referred to in the email, or an event is referenced in the text of the email.
Everybody knows the nickname, so how does that prove anything?
It could be one modicum of proof, wouldn't be the only.
But I don't think that's the same as a name. I mean, if everybody calls the person by the nickname, I don't see how that gets you any further than the name.
Could be. I suppose, Your Honor, it would depend on the circumstances. So let's say if it were between people in a romantic relationship and they had a particular nickname that was unique to the two of them, that could, for example, could be one way that somebody could say, okay, I called you baby and nobody else calls you baby and I knew it and I referred to you that way, and ergo you could say that would show that that person actually wrote that email. Other ways courts have found is to say that they reference.
See how? I mean, well, if you posit that nobody else knew, okay.
But here, don't we have exchanges of emails in which a person is looking for employment? You've got a customer who's coming in. I mean, here, if you're right, at least with regard to some of them, don't we have enough indicia to suggest that this is the kind of stuff that would be done by an owner of the place as opposed to a customer or a masseuse?
We would argue here no. And the reason is because Mr. Purdy's defense in the case was that he owned this premises, which was an art gallery, hair salon, massage parlor, a whole bunch of different things, and that he employed people in some capacity as actual employees, but that he also had a number of independent contractors that came in and out of the facility. And that those people ran what they did on their own, paid him rent as a landlord, but that he didn't manage or control the actions they took.
And he gave him his password, and they could do all kinds of things. I guess that's his story. And they tricked him, and they played. But we're just taught, what is the standard? Preponderance of the evidence?
The standard for this?
The judge is saying, okay, I've got this. What is the standard that the judge uses to determine whether it's sufficiently authenticated to come in? Preponderance of the evidence?
I would say so, yes, Your Honor.
All right.
Are there any business or billing records of the defendant on the computer?
The forensic expert didn't testify to any, no. But it is undisputed that the computer did belong to him. He had only gotten it some number of months prior. His son helped him set it up. And I do agree with Your Honor, with Your Honor that it's not the most prudent idea to give your password out to everybody. If I could defend what good decisions my clients do and don't make, I may not be here very often. But the fact is, he says that he did. And the Commonwealth provided no evidence refuting that other people routinely access that computer.
So do you say, is your problem the actual evidence that connected him to the, Justice Gans was just saying, you look at this trail that connected him to the emails at trial is insufficient, or are you saying that maybe the judge didn't have enough in front of her before she let it in to begin with? Or, I mean, in other words, should there have been an evidentiary hearing before trial to see what the basis was? And would it be the Commonwealth's burden, obviously, because it's the proponent of the evidence? Is that what you're saying?
That's right. The defense attorney in this case filed a pretrial motion saying that we couldn't prove who wrote those emails, so the emails...
But the motion in limine didn't object to his emails. As I read the motion, it just objected to the emails that were coming in response, saying we don't know who really wrote them.
I read the motion, Your Honor, as objecting to all of the exhibits. And the exhibits included both responses and the correspondence that was initiated by the person who wrote back from, presumably, Craigslist.
So is it your view that with regard to a motion in limine as to authenticity, we must evaluate it at the time that the judge denied the motion or allowed the motion in limine as opposed to the time the evidence comes in?
Yes, Your Honor. We would say that it would have been a bar to the admissibility of the evidence and the jury should never have even heard it.
But why, I mean, you're treating it as if it's a motion to suppress where we do that, but why can't a judge given all that one has learned during the course of the trial, be viewed to make the decision when the evidence is admitted at trial as opposed to preliminarily to the motion in limine? I mean, it matters here, I think, because I don't think the judge had the content of the email before him or her at the time that the motion in limine was ruled upon. Is that correct?
I believe, Your Honor, that the judge did. I think that the Commonwealth had introduced the exhibits and they had them in their hands. And the motion in limine specifically said exhibits 13 through 22, and they had the content of the emails.
I guess I just read this motion in limine entirely different. You were the defendant was objecting to any emails which did not originate from him and complains that many of these emails do not appear to originate from Duncan, but they're responses from others, and therefore we can't cross-examine those people. We don't know. That's a very different objection than the one you're talking about now, the one presumably raised at trial.
The way that I had read it, and then later defense counsel in the course of the transcript discusses it, is that because we can't make the presumption that those emails originated from Mr. Purdy, meaning any of those emails originated from Mr. Purdy, they shouldn't have come in because they weren't authentic. And then later at trial, he makes the same objection and the judge lets it in anyway. But the reason why this is a big deal is if you think about, now I'm not a specialist in probate or in divorce cases, but those are the kinds of other cases I would imagine that this would be pretty relevant, that who actually wrote it. If you have people who live in the same house, siblings, parents, people in a relationship, who can easily access someone else's correspondence, would it be fair without making the proponent of that evidence prove who wrote it, when, by the way, proving who wrote it is not that difficult. In this case, for example...
You say that. Why do you say it's not difficult to prove that he wrote it?
I list in the brief a number of ways in which I think the Commonwealth could have introduced evidence that I think would have been sufficient to show authenticity, if it were true. They could have showed, for example, of the 1,500 emails that were seized, was there anything stylistic in these few that they decided to enter as exhibits that would prove that Mr. Purdy wrote them? Could they show that the facts that were alluded to in the emails actually carried through and happened? Could they have contacted any of the recipients of the emails and said, did you speak to this person on the phone, or do you know that it was Duncan Purdy was actually the person that you were corresponding with? And those are the kinds of offers of proof in other cases, like in the Siddiqui case is the one that comes to mind. It's a federal case, but in that case, the emails did come in. And the reason they came in was because in addition to the fact that it was Mr. Siddiqui's computer and his email account, there were lots of things that were, the facts of the emails were things that only he would have known. The relationships that he had with the recipients were relationships that only he could have written about and someone else couldn't have written them. And in a case like that, the court went to pretty great measures to actually make sure that this was what he said and it wasn't imputed to him but said by somebody else. I would also say, Your Honor, that in addition to just sort of the easiness of proving it, we can't underestimate the danger of hacking. Now, this is something where I feel like the law and technology are moving in slightly different directions, and it is helpful for litigants to know how much we can keep pace with what people are able to access.
Is there anything in the record about that? About hacking and the effect of hacking on...
No, only in my brief. But I mean, I would say that, you know, if you look at the trial attorney's argument, his argument was that it wasn't written. Now, that is not hacking per se. Hacking is something that's illegal, but it is unauthorized or authorized access by another person to a particular account. There are a number of celebrity examples that I cited too. I would posit that if any one of your honors went to your computer on a given month, you would have a friend send you some email that was accidentally broken into. That happens to me all the time. It's fairly simple. You know, take the example out one step. I could open up a Google Mail account in anybody's name and send an email to someone and make a signature block that says, "Hi, my name's Brad Pitt, and I love you," and send it off to anybody else.
At the same time, you rely every day on the fact that the emails which you receive are from the people who send them, recognizing that if there's something screwy about the email, they may not be. Why can't a judge in deciding authenticity do the same thing? That if a rational juror would conclude, based on a preponderance of the evidence, that this is the real thing, that juror is entitled to give it whatever weight that juror thinks is appropriate.
Because that reliance is vulnerable. And I don't think that the party against whom it's being admitted should be punished when proving that it's actually what it is not that difficult for the proponent of the evidence.
Well, isn't that part of it, though? I mean, the reason that you rely on it every day is because the message, you're looking at the contents, and the contents connects to the person who purports to have sent it.
And I would know that if it's from somebody that I know by looking at it. I have just no more time. If I could just indulge the court for just 1 minute to address the second issue, which is
No,
the
I'm
issue.
sorry, your time is up. Thank you.
Okay, thank you, Your Honor.
May it please the court, my name is Carrie Ann Kilcoyne. I'm an assistant district attorney from Middlesex representing the Commonwealth. The emails were properly admitted into evidence where they were sufficiently authenticated. And I'd just like to, if I could, clarify the motion in limine concerns. My understanding, reading the transcript, is at the time of the motion in limine, the judge wasn't particularly clear on what emails were going to be admitted, and neither was the defendant. At that time, it was just known that there were about 1,500 emails that were found on this defendant's computer, that he was provided with a disk of those particular emails. And it wasn't, I don't believe from reading the transcript, it was clear which email specifically the Commonwealth was going to introduce at that time. At the conclusion of the motion in limine, there was some discussion that perhaps the Commonwealth could pinpoint exactly which emails would be chosen, and then they would go from there, and that's where you sort of pick up when the emails were actually admitted.
And is it your view then that we should evaluate the decision of the court at the time that they were admitted in evidence, or at the time that the motion in limine was allowed?
At the time that they were admitted in evidence, Your Honor.
But if you, let's just posit for a second that you need more than just that the computer is owned. Let's just posit maybe you even need more than the computer's owned. You've got a password, and you've got the email purports to be signed by the defendant. If we wait until trial and there's been nothing more, then we're going to have a retrial every time. I mean, assuming that the email matters to the case.
Right.
I mean, why wouldn't you do it as a motion in limine and have a decision based? I mean, either whatever the standard is, to make sure that at that time the standard for admissibility is met.
I suppose that's the way that the defendant approached that in this particular case. Just reading the transcript, that appears that the way that it was handled. And I don't know for sure. Obviously, the discovery was given during the trial, and I can't tell whether the prosecutor specifically said we're going to admit these particular 10 emails. I guess.
Excuse me. I assume you mean the discovery was given pre-trial.
Yes. Excuse me, Your Honor. So I just there was that question. I just wanted to kind of clarify that my reading of the transcript, that's appear that the way that it went. I would just suggest in this case that the circumstances exist which imply that the thing is what his proponent represents it to be, which is that the email exists, which the Commonwealth suggests is from the defendant. And those circumstances would include the testimony of the expert witness, who was a detective, that he testified that the emails were located on the hard drive of the defendant's computer that was found in his business, that he told the police that it was his computer and that he specifically used it. He provided each password that was necessary for the different applications. He provided those passwords from memory.
How many passwords were there?
Well, there's not specific evidence of how many passwords. The evidence was that each application required a separate password, but there was no specific testimony that he provided.
Application.
Well, I would assume that email is an application that was on his computer.
A job application.
Chat, yes. I'm sorry, Your Honor?
A job application.
A job as an app.
No,
an application, I believe, is a computer
You mean whether-
application that you
whether
have to
you-
click in for Microsoft
go-
Excel or Microsoft Word, those particular applications. There wasn't any specific
Well, it would matter
testimony.
if there were 20 what you call applications, and he knew 20 passwords, or if there were 2. I mean that would be.
Well, we know it's his computer. But are there cases, I take it the basis that you're arguing is it's his computer.
Correct.
The emails are found on the hard drive.
Correct.
He knows the passwords from memory.
Correct.
And the emails are signed by him. They have his name on them.
Correct, yes. And the email address is specifically his name as well,
okay.
which I think makes
so
a difference.
my question is, the defendant cites some cases. I'm just wondering in terms of as electronic communication has increased, and there are obviously decisions out there, whether there are cases that you're looking at and saying, see, these courts have said that's enough, as opposed to some inquiry into the contents and connecting the contents to the proposed, whoever it is it's being sought to suggest that it's their email.
Sure. I think each decision looks at it on a case-by-case basis. I don't think there's a certain number of factors that are necessary for each case to say, yes, these are authentic and we'll let them in. I think each case looks at different factors. For example, there are, there's in the interest of FP, which I've cited in my brief, which talks about those were more chat logs, and that there was evidence of a screen name, which wasn't associated with the name of the defendant. So it was a little different, but the defendant in that chat said that, this is so-and-so, this is Joe. And then there was some content. Based on the content, it was determined that those were actually from him. There are other cases which suggest, in the Savavian case, United States versus Savavian, where there were separate sets of emails. One set of email included the specific name of the defendant in that. In that case, it was looked at the name of the email.
But wasn't there also in Savavian content?
There was content as well, and there was that he had signed it, I believe. But there were a separate set of emails which didn't include the name of the defendant. I believe it included a business name. And it was looked at in those instances, well, let's look at the content. We don't have a specific email address, but we do have content. And we can compare those emails to the emails that have the name of the defendant and were signed by the defendant.
So in this case, doesn't the content goes to the question of guilt? I mean, what I thought was that a lot of the emails were asking people to come work as masseuses, i.e. prostitutes or whatever. And so if you look at the content of them, that all depends on whether the defendant is doing what he's being charged with.
Well, I think some of the content was, I don't know if it was so much, but I need you. One of them was personal secretaries with benefits. So that's a little bit different than a masseuse. I'm not sure exactly what he means. Some of them, the name was arouse me or something of that nature. So the content wasn't necessarily, and some of them had more content than others. And some of them were just signed with the defendant's name or the letter D. And some of them had the message erotic plumbing service or erotic massage for plumbing service with no particular content, but I think we can trace those back because there was testimony that the defendant lived in Revere. So some of the content in this particular case, it more goes to that the defendant was running a business. I don't know necessarily that he was looking for people to work in his business and in the particular business that he had.
So what is in this case, do you say that it is enough that it was his computer, his email address, passworded, signed by the defendant, period? Or do you say that we should look and see whether the content is consistent with it being from or to him?
I think you can include the content. I would suggest, we have all of those factors. We have that. I think that the fact of where it is found is also important, which is perhaps a distinction that was made in Commonwealth versus Williams, where these were just MySpace messages. We're not sure where they were found. They were just the witness went on the computer and pulled them down and printed them out. There's really we don't know where they were found, what computer they were off. So
I guess my question more precisely is the content one of the elements which we must look at or a judge must look at in deciding whether it's authentic?
I think it certainly helps, Your Honor, but I think, again, it would depend on the circumstances, the facts of each specific case. I think, where the computer was, you have that. I think it comes into contact more if this, for example, the email address is specifically Purdy Duncan at Comcast.net. If this were an email from, say, for example, About Hair, which is the name of the business, then I think content would be more important, because if it's about hair, then perhaps other people who work at that salon may be using that particular email for a legitimate business purpose, as opposed to this particular email address being in the name of the defendant.
So you're saying that some may come in based on the content and some may not?
No, I would just suggest that content is just one of the factors, and certainly in terms of email, it may be a more important factor, because you don't have a handwriting analysis. You can't, the defendant's not signing in his own hand, where he's typing it, so you can't tell that way. Although in this case, he did sign it with his name and business address and phone number. I would suggest that that's a important factor
No, but many
as well.
people have that programmed totally into their email, so that every single email has the name and the business factor.
That's true, and if that were the case...
So if somebody were borrowing a computer...
If that were the case, then I would suggest we'd have to look somewhere else. I was just perhaps that's not the case here, because he was signing it differently. If you look at the emails, there were different signatures. He signed Duncan, in some with his business address and phone number, in others he just signed with the letter D. There were some others that didn't have a signature, but you could see from the name.
I don't follow your argument that if the content of the emails had to do with hair, then they may well have come from someone else in the salon, but because then if the contents were about giving massages, then they might have come from the other people, the masseuses, and not from him.
I didn't mean that, Your Honor. I'm sorry. I was saying if the email address specifically was, in this case, the email address where these came from was Purdy Duncan at Comcast.net. If for some reason this email address was about hair.
That's the name of the address, about hair.
About hair at
subject matter, not the subject
Comcast.net.
matter.
I'm sorry. Okay,
Then it may
sorry.
be a different story. That's what I was
Sorry.
suggesting, Your Honor.
Could I ask you a question about the second issue?
Sure.
Putting Kimball and Mullane, okay, I understand they are out there. Why isn't this hearsay?
Well, I mean, certainly, there were several...
Isn't it admitted for the truth of what is being
There were
said?
several statements there were a number of statements that the officer had with the masseuse. I would suggest that for the most part, I mean, they weren't offered for example, well, I would suggest...
You tell the character of the house because you're getting the truth of what the person is saying about what she's doing there.
Well, and I would suggest that, I mean, certainly in terms of statements, that there has to be some truth to them in order to be able to believe them.
It matters what's being said. The contents matter. It's not just the fact of saying. I know I'm being obtuse, but I just don't understand why this isn't coming in for the truth of the matter stated, therefore it is hearsay, and it shouldn't have come in.
Well, again, Your Honor, I mean, I know you said putting Mullane aside. That's what the judge made the decision on. She read the cases, and
I'm
after
not saying
reading that,
yeah, right. But I just
she just
putting that as, I mean, is Mullane rightly decided? Is Kimball rightly decided? Do you think?
I would
Yeah, you
suggest
do,
that
but-
it is rightly decided.
But why?
Well, the statements, I mean, they were shown to show the character of the particular house. Not that that was what was going on there, but that...
Well, if somebody stepped outside, if one of the masseuses stood outside the place of business and said, "Come on in, this is a house of prostitution," describing what's going on inside, and the person did not testify, would that have been admissible?
I don't believe so. I believe that probably would have been the Commonwealth versus Joseph Harwood case, where there were individuals who were outside talking about the services they had just gotten inside, and someone overheard. And in that case, the conversations were not properly admitted.
Well, these conversations were essentially negotiations for a contract, weren't they? They were offers to contract for services.
Yes, they were offers.
So are they non-hearsay on that basis? They're operative words. They're terms terms towards negotiation for a contract.
Yes, I mean, I would suggest that they were offered for a non-hearsay purpose, and that the reason the judge decided. I mean, there was no limiting instruction. The instruction requested by the defendant wasn't correct. And regardless of whether a limiting instruction should have been given, these statements simply were cumulative of other evidence, so that there was no prejudice to the defendant.
I have a question. I'm sorry about your quoting the instruction requested by the defendant and saying it was incorrect. Are you saying that the requested instruction was incorrect only because it didn't tell the jury how such statements should be considered? Is that what you do in your brief? You only say that it's wrong because it didn't? I mean, that's all I could see. Or are you saying there's some other reason why it was incorrect?
I believe that's what I was saying, Your Honor, that
Tell them how. Okay.
that it was just ended and that the judge substantially gave that instruction in her own instruction as well, Your Honor. I see that my time is up. If there are, or almost up, if there are any further questions, I'd be happy to answer them. Otherwise, I will rest on my brief.
Thank you.
Thank you.
All rise. Hearing, hearing, hearing. All persons having anything further to do